I will speak loud. I'm loud. I'm Italian. There's no Italians who are not loud. Well, thank you to the audience for showing interest in our panel's topic. Now I'm taking you on a symbolic or imaginary trip to China. I'm going to cover some of the topics that have been covered, the panelists before me have been covering as to Europe and UK. What I want to say at the beginning is that starting with this, I think every one of you has heard or read somewhere that China now has implemented very modern set of IP laws, is now part of most treaties, all treaties, relevant treaties and conventions regarding IP rights. The problem with China is always that they have the beautiful laws there and then it's lacking in enforcement or administrative or judicial enforcement whatsoever. This has there's a foundation of truth on this, but I think has become what I call a urban legend that has affected and is affecting corporate decisions as to when, if, and how to enforce IP rights in China against major acts of infringements by competitors. We're not talking about just counterfeiting. We are talking about infringement of high economic relevance. Based on my experience, and this is what I want to go through today, is that this urban legend, it may be true to a certain point, and it still holds in many cases, but there's a light at the end of the tunnel. There are examples that rule of law applies also in China. There are courts that can decide based on the law and not based only on local factors or political, based on political influence coming from higher echelons of the government. And I'm going to go through especially, there's a lot of automotive cases here, but not only automotive cases. What I want to show is that at least the Supreme People's Court has, from 2009, taken a stand and on creating a consistent test for evaluation of design similarity in patent infringement cases in China, whereby before there was no such regulation, and it was true. It was the Wild East in that sense, right? Before I do that, I'll talk a little bit about what design patents look like in China. As to the general definition, I would say it sounds very similar to what could be a community patent. The word ornamentation is not present there, but ornamentation is an element that will come into question when determining the scope of protection of a design patent in China. Major feature here is the aesthetic feeling, the aesthetic value. Therefore, designs, like in Europe, go in between copyright and trademark because they cover the aesthetic value of industrial products and not their origin. Because that would be, like in Europe, that is the function of a trademark. Designs are patented.